Hello, Mr. Adam. Could you briefly explain what happened?
This is Miss Rina. She is selling delicious Sarawak layered cake. This is Mr. Adam. He is the owner of Borneo Serenia shop. Mr. Adam's shop is adjacent to Miss Rina's cake shop. For many years, Miss Rina's premises had a sign on the wall of their building that enwrote 4 inches into Mr. Adam's shop. At some point of the time, the sign was replaced with a new sign that enwrote some 8 inches into Mr. Adam's airspace.
What the expensive one, the medium one?
Oh, Miss Lina, it seems like you just got a new sign. I like it.
Yeah, how is it? I paid a lot for this. I'm glad it came out well.
But Mr. Adam, don't you think her sign is intruding your space more than before?
Are you sure about it? I guess I will have a talk with her.
Hey, Miss Rina, do you realize that your new sign that you already made entering my space more than before?
Huh? How is it your space?
Look, your new sign that you made entering my space a little bit more than before. I hope you can reconsider it.
Yes, and it is actually considered as a trespassing, Miss Rina.
Yes, I agree. You are actually trespassing Mr. Adam's airspace.
Also, this is not your first time doing such thing. Before this, your sign has already entering my space for about 4 inches, you know. Do you realize it? I can take a legal action since you're trespassing my airspace more than before. That's what happened, Your Honor.
Your Honor, my client, which is Mr. Adam, also has sought for an injunction for the removal of the sign. However, the defendant has declined my client request. Defense counsel, your response?
Your Honor, while it is true that my client, Miss Rina, declined the initial request to remove the sign, this was not out of malice or disregard of the law. Furthermore, the previous sign had existed for several years with no objection. My client assumed, perhaps mistakenly, that the continuation of the arrangement was acceptable. Your Honor, we respectfully submit that an outright injunction may be disproportionate given the minor nature of the intrusion, approximately 8 inches into the airspace, which causes no physical damage, no obstruction to access, and no significant economic loss to the plaintiff. We request that the court consider either granting my client a reasonable period to adjust or modify the sign. Ms. Rina is open to an amicable resolution and willing to act in a good faith.
Thank you, counsel. The court appreciates both party cooperation. Have you any further submission, plaintiff? Yes, with your pleasure, Your Honor. Okay, while we acknowledge the defendant willing to compromise at this stage, my client has already suffered ongoing inconvenience, including the blocking of his business signage and disruption to customer visibility. The defendant refusal at the time of notice left my client with no choice but to seek court intervention. An injunction is not only appropriate, it is necessary to prevent further disregard for property right. Thank you, Your Honor. Very well. Having heard of both sides, the court is prepared to make its ruling. This court finds the defendant's signboard does constitute trespass into the plaintiff's space as per Kelson v. Imperial Tobacco, and that the plaintiff is entitled to an injunction. However, in the light of the defendant's willingness to cooperate, this court grant a suspended injunction. The defendant is to remove or alter the sign to eliminate enforcement within 14 days from today. Should this not be complete with, a permanent injunction will be enforced. Each party shall be their own legal cost. Case closed.
In the case of Kelson v. Imperial Tobacco 1957, the court dealt with a situation where a company had placed an advertising sign that projected several inches into the airspace above plaintiff's property without consent.
This case is significant because it reinforced the legal principle that a landowner rights extend not only to the surface of the land but also the airspace above it, at least to be a height necessary for ordinary use and enjoyment to the land. As a result, the plaintiff was granted an injunction. This is a court order requiring the defendant to remove the trespassing sign. The court reasoning was the trespass is actionable even without proof of damage.
Sorry,
Yes.
the court's decision is out. When I said adjust the sign within 2 weeks.
Yeah, honestly, I didn't think something like a signboard could turn into a big issue.
Same, but I guess it was small things matter when it comes to property rights. Boundaries are boundaries.
That is true. But I also understand Dina's side. He didn't seem like he want to take advantage. He just want to promote her business.
Wait, what if we go there?
Sure.
And Adam, from what I know, isn't unreasonable either. He just wanted his shop want to be really visible.
In the end, I think it's a good thing that the court gave the decision. It's not too harsh or too lenient.
Actually, Musila, I didn't want to fight about this. I just wanted my boundaries to be respected, you know.
Yeah, I thought so. I never really think that it could extend it that far. I thought I would find my limits. I wasn't trying to cause any harm to you.
I understand you. But when I saw it blocking my shop sign again, I felt like I had no choice.
I understand now. I wish I had taken your complaint more seriously for the first time.
We both could have handled it better. I think we should have a slow talk about this problem before going to the court actually.
It's okay. At least we're fair now, not just as business owners, but also as neighbors who's trying to move forward.
Agree with you. I'm glad that the court gave us a fair outcome to both of us. I don't want to see your business to suffer more. I just want things to be done right.
Yeah, I'll fix the sign soon. I want to keep things peaceful too. Maybe after this we could put all this behind us?
Yeah, let's move forward. I hope there will be no more signboard walls, okay?
Okay.